Welcome, good evening, good morning, good afternoon, wherever in the world you are joining us from. It's wonderful to see so many of you back here for our second year of the Essex Public International Law Lecture Series. My name is Dr. Emily Jones, and I am a lecturer in the School of Law at the University of Essex, and I am, of course, the co-founder and co-convener, alongside my fabulous colleague, Dr. Megan Wong, of the Essex Public International Law Lecture Series. It's my pleasure to be your host for this evening's lecture, and we are very, very excited to have with us today the highly esteemed Professor Preamble, who is here with us to open the series for the start of the new academic year. So it really is an honour. I will hand over to Dr. Wong shortly to introduce our esteemed speaker, but before I do so, I just wanted to say a few words about the series. So as some of you may know, but those of you who are new to our series may not, the Essex Public International Law Lecture Series is co-founded and co-convened by myself and Dr. Wong, and we are both generalist international lawyers, which is a very important theme of the evening. But Dr. Wong is very much a formalist, and I am a critical international legal scholar. This series is built upon our deep respect for one another's scholarship, as well as, importantly, our friendship. And across these differences, we've really built this series, touching on multiple different issues across formalism and critical approaches, and all of those in between. The series, therefore, really prides itself on building on these two important intellectual traditions of international law, both formalism and legal practice and critical international legal theory. And today's lecture on the universality of international law, of course, promises to be a very good example of bridging these two worlds. So I would now like to take the opportunity to introduce you to our chair for this evening, Dr. Wong. Dr. Megan Wong is a lecturer at the School of Law at the University of Essex and is the founding director of our LLM in International Law degree. She is a generalist public international lawyer with interests in several specialist subfields of international law, including the international law of the sea, international environmental law, international criminal law, and the law on the use of force. Dr. Wong has advised states on many issues of international law and has published on canonical topics and specialist subfields of public international law in many leading peer-reviewed journals, including a very exciting forthcoming article in the International Comparative and Law Quarterly. She is co-author together with Malgosia Fitzmaurice and Joseph Crampin of a forthcoming International Environmental Law Cases and Materials book, which is coming out with Edward Algar, and is also author of a forthcoming monograph, which is signed with Cambridge University Press, entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. So without further ado, Dr. Wong, over to you.
Thank you, Dr. Jones, for the kind introduction. It is wonderful to be back with you in our series this new academic year. And it is also wonderful to see our colleagues from the School of Law and many of our students in the virtual audience. For those of you joining us for the first time, welcome to our series. And for those of you who have joined us before, welcome back. We are delighted to be back with you again. I'm honored to chair today this magisterial opening lecture about the universality of public international law in the year 2021 and in the years to come. When Professor Dupuy first gave us the title, I just thought, wow, what a title, and also what a privilege to open our lecture series with this very topic. For not only is it a reflection and overview of the unity or universality of international law in 2021, but Professor Dupuy's name is synonymous with the universality of international law. As some of you may remember, he delivered the Hague Academy General Course on this very topic at the start of this millennium in the year 2000. Some of us may also be familiar with his response to Marti Koskuniemi in the European Journal of International Law in 2005, which indeed we know is a journal that he had co-founded. Thus, it is a privilege for Dr. Jones and I and the School of Law at the University of Essex for Professor Dupuy to open our Public International Law lecture series this year on this topic. Before I introduce our speaker, let me go through a few quick housekeeping rules. Professor Dupuy will speak for about 40 to 50 minutes, and then this will be followed by a Q&A. Please feel free to type your question in the Q&A box. I will read out your name and affiliations unless you opt to be anonymous. And I am now pleased to introduce our speaker, Professor Pierre-Marie Dupuy. Professor Dupuy is Emeritus Professor at the University of Paris, Panthéon-Assas. He was also a professor at the European University Institute in Florence and professor at the Graduate Institute of International Development Studies in Geneva. He is a member of the Institut de Droit International. A generalist international lawyer at heart, Professor Dupuy has written extensively and diversely in various generalist and specialist subfields of international law, including the law of international responsibility of states, sources, theory and history of international law, international human rights law, international environmental law, international law of the sea, international investment law, and international dispute settlement law. His PhD on the responsibility of states for damage caused by technological and industrial activities is reflective of his concern already early in his career with how to effectively use the law to protect global commons, the environment being chief amongst them. And his most recent work includes editing a research collection on customary international law with Edward Elgar, which is forthcoming this year, so something to look out for. As I had already mentioned, he delivered the impressive general course at the Hague Academy on the unity of the international legal order. And in addition to his leading scholarship written with an unparalleled elegance and erudition, Professor Dupuy has an illustrious and extensive practice, which includes his career as counsel and advocate in a large number of cases before the International Court of Justice, and he sits regularly as arbitrator in investor state cases. Last but not least, Professor Dupuy has taught several generations of scholars and practitioners in international law. Some of them are in the virtual audience today, and it's such a pleasure for us to have you. Whether in Paris, Florence, or Geneva, Professor Dupuy has maintained a personal investment in the success and intellectual growth of his students. And of course, as he is fluent in several languages, this has allowed his teachings to reach a wider audience and his writings to engage with the growing diversity or unity of voices within our discipline. In 2015, Professor Dupuy was awarded the American Society of International Law Manley Hudson Medal. And now I will leave to our speaker to open our lecture series. Thank you.
Thank you very, very much for these two nice presentations. Let me tell you that I'm grateful for your invitation. It's a pleasure for me and it's a privilege. I would say the problem with an emeritus professor, in particular in, let's say, continental Europe, is that you don't have anymore so many opportunities to teach. You provide me tonight with one of them, and I'm very thankful. Well, rightly or wrongly, but we can discuss that later, I have the impression that the internationalists today too often avoid addressing a subject that concerns us all because it also relates to the future, to our common future. And this issue is whether not only the states, but also the entire world's population are still fully aware of the fact that they possess a system of law, of primary and secondary norms at the international level, the validity of which is in principle recognized by all. Does humanity as a whole, or at least some part of it, know that it is endowed with a set of norms, rights, and obligations that everyone considers to be made in more or less the same way everywhere, and that once constituted, they apply to all those they are supposed to oblige? Do people know that there is not only an international system of law, but also an international legal order, which is not exactly the same. An order is a sense which was theorized by people like Kelsen, of course, but also Santi Romano, Maurice Oriou, Hersch Lauterpath, Georges Sell, Wolfgang Friedman, an international legal order which provides the same legal language at the international level, a condition for countries, but more generally, the international community, not only the international community of states, with the possibility of communicating and of creating, developing new norms and applying the existing ones. I must confess that French professors always, when they, most always when they teach, do that in two parts. It's a tradition. I'm sorry. I will more or less do the same. And the title of my lectures, of my lecture already gives you the two main parts. First, the phase of the growth of the universality, and then that of its decline, before, in an enlarged conclusion, we will discuss a series of things, in particular, our responsibility as international lawyers. Let's start with the first of those two parts, the growth of the universality of international law. And as you see, I have chosen to adopt a historical perspective so that we can really grasp the overall evolution and the point where we are now, as I feel it, but once again, we shall discuss it later, after the lecture. First part, the growth of the universality. How and during which period of time one could speak, using a dangerous concept, one could speak of a progress of international law in the sense of the progressive enlargement of the scope of its authority. Let's begin, first of all, with the intentions, which means with the Charter. As you all know, the preamble of the Charter sounds in kind of a religious way. We, the people of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and so on, you know. That is a declaration which, per essence, sounds and wants to be universal. And as you know, it was followed only 3 years after by the Universal Declaration of Human Rights, which begins by saying, whereas recognition of the inherent dignity and of the equal and inalienable right of all members of the human family is the foundation of freedom, justice, and peace in the world. Well, of course, we may from the outset say that the voice which we have just heard sounded universal, but that in its origin it was not. We know that there were at the beginning 2, then 3, then 4, then 5 countries which played an important role in the concept of the Charter and in the draft of its content. And that a few years later, one could say the same. There were in particular 2 important people for the drafting of the Universal Declaration, a Frenchman, René Cassin, and Lady Roosevelt. So that is not that universal, after all, you could say. Those were people coming from the West, but pretending to speak universally. And we will come back on that. This is one of the main points of the problematic, which will be to be discussed. But the importance is that the intent, at least, was to launch a set of principles of a universal dimension. As Dr. Wong referred earlier, mentioned earlier, I had an opportunity in 2005 to answer a very talented talk by my good friend Martikos Kenyemi, who delivered a speech when launching in Florence the European Society of International Law, because he had, with his talent, his usual talent, he had sharp words against the fact that our international law came from the West. And I agreed, and I did not. First of all, Marty, 2 points only. Marty delivered this speech in 2005. Had he forgotten that already in the very early 60s, long before, a group of international lawyers, and very talented too, had addressed the issue of universality. And I will in particular mention here Mr. Mohammed Bejawi, who will be later the judge and then the president of the International Court of Justice, who in 1979, after the launch of the Declaration on the Establishment of a New International Economic Order, published both in English and in French, a book under in the series, UNESCO series of new challenges to international law, which was called Towards a New International Economic Order. And Mr. Bejawi did not wait for the early 60s for saying, I quote, international law has faithfully interpreted this international economic order, consolidated its foundation, disguised as indifference or neutrality. It is in effect a permissive law intended for a liberal or neoliberal world economy based on certain people's freedom to exploit others. The problem, he continued, with traditional international law is not so much that it is actively unfair, but that it has not done enough to close the economic gap between North and South. Now, the interesting thing with what was called very early in the French doctrine and in French, le droit de la décolonisation, and then le droit du développement, law of development, was called like it by my former teacher, a great international lawyer of the name of Michel Virali. The interesting with the law of development is that precisely right after having criticized the one-sided origin of international law, the developing countries and a small group of international lawyers. Let's speak of Mohammed Bejawi, Mohammed Benouna, who is still a judge at the ICJ, Professor Georges Abissab of Egyptian nationality. They gave all their talent to reformulate international law, including customary international law, and in a way to make it possible for developing countries to adopt it. So one of the interests of the law of development, I can come back on its very definition later if you need it, was precisely that on the basis of a critique, he was able to make out of the old body of law a corpus of norms which were acceptable and actually accepted by le tiers-monde, the third world, the developing countries. And one of the quickest demonstration of that was the launching in 1969 of a text to which we refer every day, which was definitely the outcome of a common work of delegations coming from the South as well as from the East, West, and also, by the way, of the East, which at that time was completely controlled by the Soviet bloc. I'm speaking, of course, of the convention, the Vienna Convention on Treaties, of which you know the content of Article 53, which makes two things. First, Article 53 launches the concept of international community of states as a whole. And second, it says that this community, per excellence universal, has a set of common principles because it has common interests, jus cogens. And by the way, I make it very clear, jus cogens is general international law, is part of customary international law. There is no doubt about this. We can come back at that also if you want. You would say, well, international community, how can you speak such a way? Look at your papers. Don't you read the paper every day? How can you speak of an international community? Well, ladies and gentlemen, just a second, please. The international community is a legal fiction. And there is nothing more evident, existent, real than a legal fiction, at least, where as long as you remain within the law. The equality of states is a legal fiction, but it is fundamental, and the International Court of Justice had an opportunity to repeat it again and again. So the important thing is not to say whether there is in the sociological or political reality a community, because the answer is on this side, there is one at some points, and the day after, there is none or almost none. But the permanence of the international community as a legal concept, making part of positive international law, makes no doubt, because it is in the law. You find the concept in a bunch of international conventions, and it is part of international customary law. What is interesting is that at the same time, And you see that under the point C of my first part, if you are confronted to the slide. At the same time, as you know, the Convention on the Law of Treaty was 1969. The dates are important. 1 year after, there was a UN declaration on the seabed, which said something incredible, which was that the seabed was the common heritage of mankind. Mankind as kind of a new subject of international law. Can you imagine something more universal than mankind? I can't. And there was, of course, kind of a coherence between 1969, the launching of Youth Codes, 1970, the launching of the common heritage of mankind, of which you find an exact formulation under Article 137 of the Law of the Sea Convention. No state shall claim or exercise sovereignty or sovereign rights over any part of the area of the seabed of its resources, nor shall any state or natural or juridical person appropriate any part thereof. And more or less, there are some nuances. The same could be said about the outer space. There were some consequences of this development, which, to go quickly, appeared with the Gulf War. That was almost 20 years later, 1991. But in 1991, which was the conclusion of a period which had been dominated by the era or the period of peaceful coexistence, and peaceful coexistence was something very precise. And I insist on this in terms of intergeneration of international lawyers, because due to my age, I was already very young, but I was already a young student and then teacher of international during that period. And that period was extremely rich. That was a period during which the law of the Sea Convention was negotiated, but there were many other producers of it, including, starting with, of course, a bit earlier, the 1970 Declaration on Friendly Relations of States. And that period ended up in 1991 with the collapse of the Soviet Union, with at least from the beginning of 91, with a Soviet Union which had, so to say, joined the West and the South, which had only 1 year more to live because it disappeared in December 1991. And a miraculous event appeared. The Security Council of the UN spoke with one voice. One voice. Is that possible? But we had not seen such a thing for decades. And then it came. And the impact of that was efficiency. The impact of that was that within 2 weeks, the allied countries from East and West and South exercised such a heavy military pressure on Iraq that it came back to its original frontiers, and that Kuwait, the territory of Kuwait, was free. And after that, there were a series of initiatives which gave the observers the impression, and which was not only an impression but a reality, that at the end they were watching a UN, a United Nations organization, which was efficient because unified, including among the 5 permanent members of the Security Council. Now, that was also the time, 1995, 50th anniversary of the UN, when a number of very talented and stimulating international lawyers, including German ones, starting with my good friend Christian Tomuschat, said, and I quote, "It has become obvious in recent years that the Charter is nothing else than the constitution of the international community." The constitution of the international community. Now that universality has almost been reached, it stands out as the paramount instrument of the international community, not to be compared to any other international agreement. That was 1995. But now we have make to change the slide because we have to deal with the challenges to universality. And here, surprisingly enough, I begin not with facts, but with a doctrinal movement or a thesis, which was that of the fragmentation of international law. During the 90s, you could not study any kind of issue without saying that international law was fragmented. Well, there was a few exceptions, including mine, because I delivered precisely at the end of that decade a general course which was called l'unité du droit international, the unity of international. I never believed, after having read the reports of Mr. Ripagan, who was the second special reporter of the ILC on the law of state responsibility and who had a very heavy burden because he was succeeding Roberto Ago, who was one of the stars of international law and marvelous technician. And Mr. Ripagan said, "Oh, but there are special regimes, self-contained regimes." And I never thought that because it was, and it is, wrong. So I wrote a book on that, which was my general course. The interesting thing is that the International Law Commission, and rightly so, devoted a series of studies to this question on the reports of the special rapporteur that was Marty Koskiniemi. And at the end of its work, there were the conclusions of a study group, which are very, very interesting indeed. Because what do they say? They say exactly the contrary of fragmentation. I just take my paper, here it is. The first sentence of the conclusions of the study group of the International Law Commission are the following. International law is a legal system. Its rules and principles act in relation to and should be interpreted against the background of other rules and principles. As a legal system, international law is not a random collection of such norms. Unity of the international legal system. And in particular, and that was very important, the special rapporteur and a number of other members of the ILC, including Professor Campbell McLachlan, insisted, and rightly so, on the importance of Article 31(3)(c), which is devoted to interpretation of treaties, and which requires the interpreter of a treaty to take into account, I quote, any relevant rules of international law applicable in the relations between the parties. And that was extremely useful. This is a tool which is now more and more used for integrating the system of norms, which is international law. So you could say your second part with challenges to universality starts rather well for the unity and for the universality. Now, unfortunately, it was not so very long. Because in 2001, I don't want to be too dramatic, on 9/11, the two towers were destroyed. And symbolically, perhaps, part of the perception of the unity of the international legal order. Well, that's rhetoric. Dupuy is trying to make a picture which is far from the reality. C'est une facilité, would we say in French? Yes, it is a bit of one. It's part of my way of teaching. But it's not only that. What happened after 9/11, 2001, was a series of cases in which, if we focus on the law of peace, contrary to what had happened during the Gulf War, some countries acted without respecting the Charter. I would even say violating on purpose the Charter and the powers of the Security Council and the rule, the golden rule of the Charter, which is 2.4, prohibition of the use of force. And those countries were not a few countries or small countries in political terms. There were 4 out of 5 permanent members of the Security Council. Do I need to recall that? 2003. The US, and I'm sorry to say the UK, and I never understood why also the UK, decided to have recourse to force in Iraq, in spite of the fact that the Security Council had adopted a very precise system by which, in principle, one should have had to wait for the conclusions of a commission of control of the progresses made in disarmament in Iraq. But they did not want that. They did not want to wait. The French Ministry of Foreign Affairs, Dominique de Villefin, made a discourse which very surprisingly was applauded by the participants, saying we have to respect the law. I don't say it, I don't pretend that France respects in every case the law. I'm not saying that, but in that case it was very clear. And in none of the cases in which I'm involving I'm getting the French did not respect the charter, and he said you have to abide by the charter and not to have unilateral, uncontrolled recourse to force. They did. At the same time, or a few years after 2005, there was, and there is perhaps a relation between the two, an attempt during the General Assembly session of 2005 for adopting conclusions which are aimed at restoring or consolidating the results of the time during which the decade before the Security Council had been respected in its authority. And there was the adoption of this declaration that you know, the final document, which insists on the necessity for the international community to have a very unified and universal set of norms. But they were referring also to R2P, responsibility to protect, the responsibility of a state to protect its own population. And there was a wonderful article by Mrs. Catherine Powell in the American Journal of International Law, saying that there was now a constitutional moment because the concept of sovereignty was changing, and that states now have a strong feeling about their duties as sovereigns. And there were a number of scholars writing PhDs, articles, organizing colloquia on R2P, already as part of positive international law. And indeed, you can say, after all, in 2011, a few years after, this time the resolutions of the Security Council were respected because action, intervention in Libya was organized on the basis of a resolution. Okay. Now, I don't hesitate to say that we should remain very, very careful when speaking of R2P as part of positive law. Why is that? Because in 2013, President Obama said at the television, and he spoke, as you know, extremely well, that there was a red line, and that immediately after he would be aware of the use by, this time, Syria, of chemical weapons against its population, then he would immediately react with force. But outside the control of the Security Council, because as you know, the Security Council would have been anyway blocked by another member of a permanent member of the Security Council, Russia. What happened is that in 2013, there was use of chemical weapons by Syria. And the US did nothing. And there was no real constitutional birth of a new dimension of sovereignty. I'm very sorry to say that. We are now with 600,000 Syrians dead and 6.5 million Syrians outside of their territory. So please, we should be very careful with R2P in connection with a reshaping of the terms of the Charter and of peacekeeping and peace promoting. Now, we are in a situation where we had to survive a series of declarations by a number of, in the technical sense of the term as envisaged by political science, populist leaders have, starting with their declarations at the General Assembly, clearly said that universal or not, international law is not their most important rule, that it must be seen in a very relative perspective, because what comes first is the nation. America first, or Turkey, or Russia, or China now. 2014, Article 2, Paragraph 4. Was not a problem for Russia to annex by force, even if there was after the military intervention, a referendum to annex by force part of a territory belonging to its neighbor. Because Russia had historical titles above Crimea. And this argument of historical rights, which have not been notched by Russia, we can come back at that, was also and is still used by China in the South China Sea. I wrote and published an article together with my son in the American Journal, which was published in 2015, if I'm correct, but which was then confirmed by the PCA arbitration based on the claim by the Philippines, that China has absolutely no legal title on the largest majority of the sea areas in South China Sea, although it is named China Sea. So this is a clear example, but it's not the only one. Those are a series of examples of the fact that the universality of the fundamental rules of international law, starting with 2.4, are really challenged. And we are witnessing right now, at the time when I speak, a very, very dangerous situation, precisely in that region, including the area of Taiwan. Now, the problem is that it is precisely now that we need more than ever to use this common language, which is called international law as a legal system, for passing new conventions and treaty simply to save the planet, which is an important goal. You cannot say the contrary. We are 1 week before the COP26. We can come back on that, but you know how it is important. And for transforming in the rugby stick sense of the term, the essay, the trial made by the Paris Convention in 2015, we need to speak with one language of norms, of principles, of vision, of perception of the universality of the rule of law. Now it's time for me to conclude, and to conclude with one thing. You and I, we have a difficulty. We work in our office, in our libraries, and we try to analyze the conduct of states. Of course, and that's a privilege, when you, as I did it several times, when you have the privilege of pleading for a state, before the ICJ in particular, you may think that you have some kind of a connection with the practice, the application of international law. But for the rest, when you simply teach the law, go to seminars, supervise PhDs, give the sense of international, the desire to study it to younger generations, well, that's a responsibility. What can we do now, confronted with this decline, evident decline of not only the authority, but also the perception of the unity of international law? Here I would like to say something. In the continental European tradition, in particular in Italy, in France, in Germany, much less in the United States, but that's not a criticism. A scholar a scholar has not to give his personal opinion on the political or social context of the object of his legal study. He must first analyze the law in itself, as it stands, and above all, as it is practiced and interpreted by the courts. And that's a very good tradition. You can see, for instance, in the Agile talks, there are a series of very clear, stimulating analysis of the reality. That's positive law in the modern way of the sense. Now, the problem is that positivism was based for a long time on the illusion that it was neutral, that it did not get into politics, without seeing that precisely positivism itself is the ideology of the neutrality of law, and that it is an ideology. It's a paradox, but it is what happens. Now, what I would like to say at the end of this talk is that positivism, even it is in its more classical sense, has now a very important, a new ideological and social dimension, which is to state the law, which is to destroy the idea among a wider public that international law does not really exist, to insist, including on the medias, which is not easy for us, I've tried it several times, that international is not always a precarious discourse, but that it binds the state that are its subject. We have to explain, for instance, that the elementary rights of the person, and in particular of women, are also binding on the Taliban. We have to state loudly that, contrary to what is said by the present Brazilian government, there are already existing rules of law, including the principle of harmless use of territory, which prohibits the the Brazilian government from destroying systematically the Amazon forest, which creates yet now more CO2 than it absorbs. We have to insist that there is one set of rules organized, that there is a legal technique which helps, which says how to use and to create and to apply those norms. We internationalists must be able to demonstrate that humanity also has another common heritage, not only that of the seabed or outer space, and that this other common heritage is international law itself. I thank you for your attention.
Thank you so much to our audience for participating. Again, this, as a chair, this has been a wealth of questions, and the generalist in me is particularly drawn to all the Vienna Convention on the Law of Treaties questions. I wish we had more time. I wish that we had more time to engage. But I just wanted to thank you for being here with us today and for opening our lecture. It is really a pleasure. And Dr. Jones, if you want to.
Yeah, I just also wanted to thank you. I see Lisbeth Lanzard has written in the chat, grand merci pour cette présentation très intéressante de Professor Dupuy. And I thought it would be nice to end in my very English accent French for you all. Such an excellent lecture. We had so many questions that we possibly cannot answer, so we'll have to send them on to you. But thank you everyone for coming to our opening lecture of the academic year. Do join us next week. We have Professor Patricia Vizier-Sellers, who will be speaking on unlocking slavery crimes, so that should be another really great one. But thank you very much, Professor Dupuy, for joining us.
And I thank you for your invitation. Thank you very much. Bye-bye.